Hi, everyone. Welcome to our Lunch and Learn. I'm Sonia. I'm an associate at SBA, and I've been with the firm since I was a summer student in 2019. My practice is probably about half accident benefits and then half everything else, including property. This is Rory. He's been with SBA since 2023. His practice is focused mostly on property, professional liability, commercial general liability, and bodily injury. If you don't already know the firm, SBA handles all kinds of insurance matters. We have offices in Toronto, London, and Kitchener. Rory and I both practice out of the Toronto office technically, but all of us work virtually as well. And so we work on files from all over the province. We should have a few minutes for questions at the end of the presentation. So as your questions pop into your head, you can put them into the Q&A box at the bottom of the Zoom. And our slides will also be up on our website if you want to take a look at those afterwards. Just a reminder, this will be recorded. And now that the housekeeping is out of the way, on to our case study. So today we are taking a close look at the Court of Appeals decision in Lalani Properties International, Inc. and Intact. This came out in July 2024. Hopefully what you're going to take away from today is either a new or a refreshed understanding of the importance of communicating and, spoiler alert, getting your insured's consent to policy amendments. If you, like me, were not in Toronto in 2010, you're also going to learn the story of this lot at the corner of Yonge and Gold, which looks like this now, but used to look like this. Okay, over to you, Rory.
Good afternoon, everybody. As Sonia mentions, the kind of key building involved with this case was the Empress Hotel, and specifically in April 2010, part of the north building of that hotel collapsed, and it forced the tenants of the building to evacuate. Additionally, in January 2011, the building, which was vacant, as I mentioned, was destroyed by a fire that was caused by an arsonist. Now, the owner of the building, Lalani Properties International, had insurance with Intact since 1999, and that insurance was obtained through their broker CG and B Group. Now, these are two very lengthy decisions, as in the original trial decision, as well as the Court of Appeal decision. So there is a lot of detail within those decisions. So today's focus will just be on the key facts. So firstly, with regards to the wall collapse, that happened on April 16, 2010, where part of the northern wall at the property collapsed onto the sidewalk. Due to that collapse, the tenants were forced to evacuate, and the City of Toronto had issued an order that required the building to remain vacant, and the Lalanis were forced to retain their own engineer in order to determine the stability of the building and whether or not it could be rebuilt. Ultimately, it was decided that the building had to be demolished. Um, Following that, however, in July 2010, the city provided a notice that they had intended to list this building as a heritage building, which affected the Lalani's ability to demolish the building, of course. They hired an architect who commented that, in fact, the building could be restored. However, before that could be finalized, the building burnt down in January 2011. Now, Intact had denied the coverage for the wall collapse and the fire, and following that, the Lalanis commenced litigation. Just very briefly, at the trial, the judge ruled in favor of Intact concerning the wall collapse and accepted the Lalanis' position regarding the fire. Now, I'm going to go into each of those issues and give you an overview why at trial those decisions were made. Now, with regards to the wall collapse, each party, so the Lalanis and Intact, presented expert evidence as to what the cause of the wall collapse was. Now, the Lalanis' experts' theory was that the wall collapsed because of vibrations caused by two nearby construction projects. It was argued that those vibrations weakened the clip bonds or disturbed the sediment that the wall was sitting on, which ultimately caused the wall to shift and put strain on the clip bonds, which forced the wall to collapse. Intact's experts came with a different conclusion that the decline of the wall or the collapse of the wall was a gradual collapse. They argued that there was water seepage that had led to freeze-thaw issues, which over time had weakened the wall's structure. Intact's expert also commented on past renovations that were carried out of the project in the mid-70s, including the addition of steel columns, beams, and bracing that could have also contributed to the wall collapse. Ultimately, the judge preferred the expert evidence of Intact opposed to the Lalanis. Now, on the day of the wall collapse, the policy that was in effect was an all perils policy that insured against all risks of direct physical loss or damage to the insured unless there was express exclusions. Because it was accepted at trial that the probable cause of the wall collapse was a seepage issue, the trial judge determined that the collapse was not fortuitous and as such would not be covered by this policy. For there to be coverage, it was determined that it had to be a fortuitous event. The trial judge actually went a bit further than that and stated that even if the collapse was fortuitous, there could have still potentially been an exclusion for coverage because of the freeze-thaw cycles involved. Now, as it relates to the fire, I'll just go into a little bit of a background into the history of the policies for the property. Now, since the property was intact, insured by Intact, annual policies were issued to the Lalanis. Now, the policy that was in effect when the wall collapsed had an exclusion for vacancies when the vacancies were greater than 30 days. It also, the policy interestingly didn't have any exclusions for vandalism and malicious acts, and specifically also deliberate fires. There was also a term in the policy that allowed Intact to cancel the policy if there was 60 days notice. Now, at the time of the wall collapse, the policy was due to expire in June 2010. And in early June, 6 weeks after the wall collapsed, the Lalanis insurance broker had sent the Lalanis a renewal package from Intact. The renewal had increased property coverage and liability limits and had a higher premium, but essentially it was the same policy that was in existence. It also included the same exclusion relating to whether the building was vacant for more than 30 consecutive days. And the renewed policy also continued to insure the building against fire loss, but did not have any express exceptions for arson attacks. So when Intact eventually issued the June 2010 renewal policy, it knew that the property had been vacant for 30 days due to the wall collapse. Now, in October 2010, Intact began to have some concerns about insuring the building in its vacant and damaged state. Intact gave the Lalanis until January 1, 2011 to confirm the demolition status of the property. Later in October 2010, Intact changed the deadline to December 2010. In November 2010, the Lalanis and Intact agreed to include a vacancy permit and wreckage value endorsement, and Intact issued the amendments on November 2nd, 2010. Now, it took about a month for the Lalanis and their broker to look at the endorsement, and ultimately the endorsement was initialed by the insureds. And the initialed endorsement was not provided to Intact, that was kept internally by the brokerage. Now, the vacancy permit endorsement was only in place until January 4th, 2011, and was not involved for the complete policy term to June 17th, 2011. And this endorsement included various perils that it would be excluded, including malicious acts and arson attacks. And on November 3rd, 2010, Intact issued a 60-day policy cancellation notice advising the Lolanis that its policy would be cancelled on January 4th, 2011. Just by complete coincidence, and I would love to know the SIU investigation into this, on January 3rd of 2011, so the day before the expiry, an arsonist set fire to the building, which consequently destroyed the building. Despite this timing, all the parties agreed that the fire was just a complete coincidence. Now, the trial judge found that Intact's attempt to amend policy in late 2010 to exclude the coverage for arson was invalid due to the non-compliance with the Insurance Act's requirement for written consent from the insured. Intact had admitted at trial that when the vacancy permit endorsement was added to the policy, they didn't think that they needed the Lolanis' consent to do the amendment because they deemed the change in the coverage as an increase in coverage opposed to a reduction in it, given the vacant state of the building and the applicability of the vacancy exclusion. The judge also concluded that Intact was stopped from using this exclusion clause as they knew the building was vacant when the policy was renewed. As it was deemed that the November 2010 amendments were invalid, the trial judge proceeded on the basis that when the building burnt down, the unamended June 2010 policy was still in operation. And ultimately, damages were awarded in the amount of $6 million to the Lolanis. And both parties appealed their respective sides of the decision. I'm going to hand it over to Sonia, who's going to talk to you about the appeal of the decision.
Thanks, Rory. So first of all, in the appeal of the Wall decision, Lolanis argued that the 1970s renos had been a fortuitous event. Accordingly, if the trial judge had given them proper weight to Intact's experts' testimony about the renos and found that they were a contributing cause of the collapse, then the loss would have come within the scope of the policy. The Court of Appeal found the trial judge had not erred. She did not make any mistake in failing to find that the renos were a contributing cause of the loss. At trial, Intact's expert did mention that the renos caused the collapse, and he did say this in his report, but he didn't go into any detail on this part of the theory at trial. There was no evidence really led that would allow the judge to make any conclusions about the role of the renos. It also turned out that when the expert had written his report, he actually wasn't aware that the north wall was built differently than the other walls. And that's when he first came up with the Reno theory. By the time of trial, he knew that the north wall was built differently, and so he basically abandoned the Reno part of the theory. Lolani also argued that the trial judge had erred in treating negligence as though it was required for a finding of fortuity, and that she then discounted the Reno theory because there was no evidence that the renos were performed negligently. In the alternative, lots of alternative arguments, Lolani said if negligence was a requirement for fortuity, then the judge should have found that the renos were negligently performed because Intact's expert had said that they were not properly executed. On appeal, the court held that the trial judge was very clearly aware that a finding of negligence was not required for a finding that something was fortuitous. And in any case, there was nothing in the evidence that suggested the renos were adverse or unusual conditions without which the loss would have occurred. And that was the definition of fortuitous in the context of the policy. Onto the fire appeal. So Intact, again, made several arguments and several alternative arguments. Their first argument was that the trial judge erred in holding that they were stopped from relying on the vacancy exclusion that was in the June 2010 renewal policy. and that mistake was made because she used the wrong legal doctrine of estoppel. She applied estoppel by representation instead of promissory estoppel. So on appeal, the court agreed promissory estoppel was actually the applicable doctrine, but in any case, the result would have been the same. So the three requirements of promissory estoppel were met. Intact had made a positive representation to Lilani that it was insuring a vacant property at the time of the renewal, and therefore it wouldn't assert any vacancy exclusion. So essentially a promise. Intact had made that representation with the intention that Lilani would act on it, and it would now be unfair and unequitable to allow Intact to resile from that representation or promise. Of course, Intact argued in the alternative, if it had promised that it was not going to rely on the vacancy exclusion, it was fair for it to now resile from that promise due to the change of circumstances in 2010. That is the uncertainty about whether the building would be restored and how long it was now going to sit vacant. Appeal court was having none of this. They agreed with the trial judge. There's nothing inherently unfair in Intact wanting to get off risk once the building's future became unclear, but it was a stop from relying on the vacancy exclusion up to the point of termination, which was January 7th, 2011. The appeal court gave a nice explanation of estoppel in the insurance context, which I'm going to share with you now. It's from a BC case, Trial Lawyers Association of BC and Royal Sun Alliance. And the court said there, in the insurance context, estoppel arises most commonly where an insurer, having initially taken steps consistent with coverage, then denies coverage because of the insured's breach of a policy term or its ineligibility for insurance in the first place. To prevent the insurer from denying coverage, the insured will attempt to show that the insurer is stopped from changing its position based on its prior words or conduct. So, in other words, based on a promise that it made. Intact also argued that the amendments to the policy were invalid in and of themselves. First, it said that the amendments did not engage Section 124 of the Insurance Act because that provision only applied to amendments that prejudice the insured, as Rory mentioned. In Intact's view, or at least so they argued, the amendments actually worked to the Lilani's advantage because the vacancy endorsement provided coverage for a building that it otherwise would not have had under the June 2010 renewal. However, the court stated that the addition of the vacancy endorsement to the policy, it didn't actually improve the Lilani situation. It wasn't giving it some coverage where it had previously had none. What it actually did was take the Lilani's from having more extensive coverage to more limited coverage, amongst other things, coverage that excluded arson losses. And so therefore, the amendments were prejudicial and were invalid. In the alternative, of course, again, Intact argued that the Lilani's had consented to the amendments. They'd done this in either one of two ways. Either they did it indirectly through their broker, who had consent, they thought, to consent on the Lilani's behalf and had consented when it emailed Intact asking it to please amend the policy. Alternatively, they said that at the broker meeting, when the Lilani family member had initialed a copy of the policy, that constituted consent. Court of Appeal rejected both of those arguments. Basically, they said neither scenario was possible because, as the trial judge had found, Intact had not even believed that it required the Lilani's consent. Basically, you can't get consent by accident or just deem something consent after the fact. Further, the consent was invalid because the family member that initialed the policy had signed his initials actually next to a sentence that said, apart from the addition of the vacancy endorsement, all other terms and conditions of the policy remained unchanged. That was not the case. There were other amendments, obviously including the vandalism exclusion. In fact, those were the very amendments or exclusion that Intact tried to rely on to deny the fire coverage. Now back over to Rory, who can tell us what this all means.
Thanks, Sonia. So just in terms of some key takeaways from this action, it's a very long decision, but very well written. And if you're looking any for specific areas that we've discussed today, Sonia and I would be happy to direct you to where those are in the case. It's key when there's any attempts made to modify a policy that those are clearly documented and there is clear consent obtained from the insured. This case is clear that any attempt to change a policy will be invalid where the agreement is contrary to the requirements of Section 124 of the Insurance Act. In addition, any when insureds are looking to rely on any exclusion, if they've previously communicated that these exclusions cannot be enforced, specifically the 30-day vacancy aspect of this case, there must be detailed communication and documentation to avoid any future estoppel claims and to ensure that all of the amendments are properly enforceable. Just from the trial decision, there's also an interesting side note to this action. The Lalanis had also sued the brokerage in this matter, specifically for the fire loss. And trial decision gave a really good summary of what is required to establish negligence against a broker, which is something that comes up quite often. So the negligence claim against the broker was based on the fact that the Lalanis did not consent to the amendments of the policy, but the claim against the broker was dismissed based on the fact that the Lalanis ultimately got the coverage for the fire loss. In order for any insured to prove that it relied on an insurance broker to its detriment, that would be enough to trigger the standard of care in these types of cases. And in this case, it was found that the broker fell below that standard of care. In this case, as they failed to challenge Intact's unilateral amendments to the policy, and also with regards to the initialing of the new policy documents, that was also deemed to be something that fell below the standard of care also per Section 124 of the Insurance Act. So with that in mind, that's all we have to say. But we'd like to invite everybody to ask any questions. I believe you can drop that into the Q&A aspect of the Zoom. If not, please direct any questions to Sonia and I directly, and we'd be happy to answer those. Okay, I don't see any questions, but maybe just give it a couple of minutes.
A lot of information to digest in a very short period of time. So if you have questions that pop up later, you can definitely send them to us then as well.
I don't see any coming up in the chat either. So maybe we'll just wrap up for today. And as Sonia and I said, if you do have any questions, please reach out to us, give us a call, and we'd be happy to answer those. And then at some point we will be putting all this together for a long form article that we'd be happy to share with all the attendees today. Thank you very much, and hope everybody has a good afternoon.
Thanks, everyone. Have a good day.